Yeah. All right. We are live on YouTube. How's everyone doing today? How's it going, everybody? Welcome to episode number 1286. That's right. Episode number 1286 of Navigating the Modern World with Eli, the Walking with Purpose live edition, live today from Red Morton Park. We've got a real doozy for you here today because this guy that I'm suing in a circuit civil case just doesn't stop playing games. In my opinion, of course, that I'm entitled to based on my First Amendment protected speech, just like he has, right? When he's not defaming me, he's protected, right? Today, we're going to be talking about, hey, Tia, how are you doing? Welcome to the show. Just waiting on Dawn. The defendant motioned sanctions on me again, 16 days before the major hearing. One more time. Today's topic is the defendant motioned sanctions on me again, 16 days before the hearing. I cannot believe what I was electronically served today by the defendant that I'm suing in my circuit civil case. And I've had a lot of things to do, and I've been getting them done. And Don and I, we spent some time together today, and we ran some errands, and we're going to spend more time later tonight once I'm done with this show. Let me try to figure out where these people are going. Are they coming my way, or are they going to go the other way? Looks like they're coming my way. All right. I was almost boxed in there with cars and people. I tried to avoid it as much as possible. But anyway, so yeah, I'm at a loss for words. I'm not upset. I'm actually just like, wow. Either this guy really doesn't get it, oh, hey, welcome to the show, Rock. Either this guy doesn't get it, or he's trying to use a strategy at the last minute before the major hearing. And regardless of what he does, I'm ready for it. Like I've said in the past, I'm not only 10 steps ahead of him every time, 100 steps. And I can tell you right now, he's going to absolutely lose this motion that he filed on me today for sanctions. He filed a motion to enforce the confidentiality agreement that we both agreed to. And he also asked for sanctions. First of all, I did not violate the confidentiality agreement. Either he knows it and he's trying to use this as a last-minute play, which I'll get more into that in a bit, or he doesn't even understand the contract that he signed, and a lot of it was his own verbiage. The funny thing is, I have an email trail saved in PDF format, still in my email server. No, I'm not going to do that, Rock. It's all good, but thank you. Or he doesn't understand the contract that he himself contributed to writing. Like, I added a lot of things in there that he wanted me to put in that are now going against what he really wanted. What was that, sir? Did you want a gag order on me? You were trying to protect yourself from trying to be gagged by me, so now because you don't like my commentary, my lawfully protected commentary. Now you want to try to gag me? You have no merit. I have all the aspects of the confidentiality agreement right here. I'm going to go over it, and I'm going to tell you, sir, you're going to be looking really, really bad, not only optically on YouTube, but also in the court. You're going to lose again. You're going to lose again. Go ahead and file this with the court. This is my protected speech to talk about this case, which was also a part of the confidentiality agreement that you supposedly didn't read. I mean, it's not possible for someone to not be this bright. Or is it? Hey, babe, how you doing? So the guy files a motion to enforce. No, I have not watched Dennis lately. What's up with him? What's up with Dennis? Has he been talking about me? Do I need to pay him a visit over there on his channel? So he files a motion to enforce the confidentiality agreement and also motion sanctions on me. And he's trying to claim that the videos that I used that are no longer publicly available, I did download them while they were publicly available. They have been filed in the court case in my second amended complaint under the exhibits. And all of that is specifically excluded from the confidentiality agreement. You folks can go to the docket, Seminole County, Florida. Well, that dude doesn't get much traction at all. And if he does that, then Dennis can file a DMCA copyright takedown. He could sue him in copyright court or otherwise. No, listen, that BVAS guy is nothing compared to the defendant in this case with me. No way. Whatever. You know, Dennis has way more subscribers, way more supporters, and the BVAS thing is not a big deal. Well, is he using a lot of his content? Then he should be able to take some action. Then DMCA copyright takedown. Anyway, I have to do my own thing. I can't focus on that one thing, but thank you. So anyway, and it's pretty packed over here right now, so I got to get through this area. So anyway, he tried to say I violated the confidentiality agreement because of the videos I was playing on ODN stream, right? And that's not the case. He's probably going to go live and talk about this tomorrow. And he's probably doing this just so he can go to his audience. I'm going to get sanctions on Eli. I filed a motion to enforce the confidentiality agreement, which is very narrowly tailored, the way you wanted it, Jamie. It's not going to look good for you in court. For the second time, you try to get sanctions on me, and you have absolutely nothing. Let's go over the confidentiality agreement, and I'll tell you what it is so even Jamie can hear it when he already knows, right? While the guy keeps soliciting money for the parody he's going to create on me, which, hey, here's the thing, Jamie, if you think that you're going to try to compare this parody with the I Believe You Embezzled, the parody that you're in progress of making with Judge Stacy, her caricature in the video, my caricature, yours, and then R.J. Sandifer as the bailiff, so far it's fair use. so far as protected speech. If you don't defame us or anything like that, it's all good. So if you're thinking, I'm going to file on that, which I'm not, unless it's defamatory. If you're thinking I'm going to file on that, so that way you can go to the anti-SLAPP hearing and try to use that against me to discredit the real defamation through the embezzlement thing, I'm not going to do that. So he's working on that, inciting donations. At the same time, he's filing a motion to enforce an agreement that I didn't violate. Here's the agreement. What this agreement is: a narrow confidentiality agreement about non-public video files exchanged in discovery. It's only for videos exchanged in discovery. Designed to ensure those specific files are only used for litigation. Prevents public reposting, sharing, or monetization of those specific files. The most important rule: scope. This is the key takeaway. The agreement applies only to covered videos. Covered videos equals non-public files produced or exchanged in discovery, Jamie. Covered videos equals non-public video files produced or exchanged in discovery. First of all, those videos I used last night were not produced or exchanged in discovery. I downloaded them when they were publicly available, and I used them as exhibits. We're going to get to the exhibits thing in a little bit. There's a clause in there. You didn't read the agreement, James. Did you just file this for the hell of it? Or, my God, I swear to God. Plus copies or excerpts of those specific exchanged files. Okay? What the agreement does not cover, this agreement does not apply to, give me a second. Can you hear me, folks? The agreement does not apply. The agreement does not apply to independently obtained recordings. You wanted that lingo in there. Independently obtained recordings. I independently obtained this by downloading it when it was publicly available. Videos that were previously public. Videos that were previously public. Third-party recordings. Public court filings or proceedings. Publicly available content. You filed a motion to enforce the confidentiality agreement with sanctions, and you didn't even read the confidentiality agreement? Or are you just trying to get a reaction so you can make more content on me? Or are you trying to distract me until the hearing? Well, there's more. I'm going to share what I think you're going to do, either later tonight or first thing in the morning. Now, let me wait until I get through this area that's typically a bad reception area. Oh, he is massively triggered. Massively. He's triggered that I got a court order on him to produce that video by April 1st. Massively triggered. And he's going to be even more massively triggered because I'm handling things the right way. The guy's trying to gag me, while at the same time accusing me of trying to silence freedom of speech. Anti-SLAPP. You're trying to gag me, man. Wow. I mean, this guy... Put a 1 in the chat. You can still hear me, folks. 1 in the chat. I want to make sure we're still rolling because this is the bad reception area. I'm almost out of it. 1 in the chat, please. Thank you, Tia. Even if content is similar or identical, it is not covered unless it was exchanged in discovery. That's the language you wanted. You emailed me on that. Whenever we go to court for this motion, I'm going to submit our email conversation. along with a copy of the confidentiality agreement that's already on the docket. And there's no way you're going to win this motion or get sanctions. I mean, like, seriously, man. This is a public case, and we have the right to talk about things publicly here. That's a part of the agreement. We're going to get to that. Oh, we got more people coming. Give me a second here. Oh, he's getting really desperate right now. Number 3, public materials are free to use. The agreement explicitly allows use of public videos, court filings, hearings, transcripts, public records, facts known outside discovery. That's all in the agreement. What can you do with covered videos? Use them only for litigation purpose. I'm going to have to go on the street because there are guys working on the street or on the sidewalk. Okay, let me come on the sidewalk here. Okay, we're good. We're clear now. With covered videos, you can only use them for litigation purposes, including motions, hearings, trial preparation, settlement discussions. What you cannot do, strict limits. For covered video, no reposting, no public sharing, no streaming or rebroadcasting, no monetization, no commentary or reaction content, no sharing with third parties outside the case, no edited clips or compilations for public use. Who can access covered videos? Only the parties, the court and staff, and experts and consultants if they agree in writing to the following agreement. To follow the agreement. Number 7, court use is allowed. Covered videos can be used in court. Parties should use limited excerpts or timestamps when possible. Avoid unnecessary full public filing. Give me a second here. Number 8, critical speech and fair use protection. Something you wanted in this agreement, James. This is one of the most important sections. This agreement is not a gag order. It's right there in the agreement, man. This agreement is not a gag order. Oh my God. It does not restrict talking about the case, expressing opinions, commenting on public materials, discussing court filings or proceedings, using fair use for public materials. You can still analyze, critique, discuss, reference as long as you are not reproducing covered videos. But you filed a motion to enforce. Someone's playing some Tupac, California Love, man. That's a great song. You filed a motion to enforce the confidentiality agreement on me, and you asked for sanctions when I didn't violate the agreement. You want to know something? You haven't given me one covered video yet. It is impossible for me to violate it because the only covered video is going to be the one that you've been court ordered to give to me by April 1st. Dude, you really need an attorney. You really need, oh my God, man. Your Honor, Honorable Judge Stacy, Eli is laughing at me publicly because I'm a horrible, pro se, self-represented litigant. You are. That's my opinion. It's not going to affect my court case. I don't bring this into the court. I'm just here to publicly respond to nonsense. Number 9, no expansion beyond videos. The agreement applies only to the actual video files exchanged. It does not apply to general discussion, opinions, arguments, impressions. As long as you are not reproducing the actual covered video content, you are outside the agreement. Number 10, copyright and rights. The agreement does not give permission to use copyrighted material, but there is fair use. All rights and objections are preserved. This is not a copyright court, by the way, so they can't adjudicate copyright. We can handle that when we get to federal copyright court, James. You can file a countersuit if you like when we get there, but this circuit civil case is not the place for that. Third-party recordings are not automatically authorized or validated. Number 11, duration. The agreement lasts until the case is fully finished, including appeals. After that, materials must be returned or destroyed within 60 days. One archival copy can be kept for legal purposes. Number 12, enforcement. If violated, the party can ask the court for injunctions, sanctions. Or other legal remedies. Bottom line, what the agreement does. Is this guy going to keep running around this same area? What the agreement does, protect specific non-public video files exchanged in discovery. Keeps those files litigation only. Prevents reposting and monetization of those specific files. What the agreement does not do, does not restrict public speech, does not cover public content, does not apply to independently obtained recordings, does not limit fair use or commentary. The summary in one sentence: this is a narrow discovery handling agreement, not a restriction on public speech or commentary. Someone is definitely restreaming me right now. I wouldn't be surprised if it's the actual defendant doing it, because I'm hearing that Bill is not doing too well right now. Oh, it is, Bill? Okay, give me a second. All right. All right, we should be back. All right, can you guys just leave me alone? All right, we are back live. We are back live. Can you put a 1 in the chat if you can hear me? Back live. We are back live. Can you put a 1 in the chat if you can hear me and see me? Put a 1 in the chat if you can hear me and see me clearly. Put a 1 in the chat. Thank you. Yeah, no, I had to tell that there's somebody back there, you know, trying to do something sneaky, and I said, just leave me alone. Went offline, and then they just backed off because I checked them. Yeah, Bill is restreaming me, and Jamie is there. He has over 40 in the box. I want to put on the record that that third party, Bill, with the defendant, are in the chat there, and I got a screen recording. Oh, Deanne, if you can go and screen record Bill's stream, I would appreciate that. If you can screen record Bill's stream with the chat, Jamie is in there. And so here's the thing, Bill. If you're going to restream, why don't we talk? And why don't you ask your friend Jamie why he filed a motion to enforce the confidentiality agreement when I didn't violate it. He filed a motion including sanctions. Hey, GLM. Let's talk about this. Even to Bill's restream. Let's tell Jamie's audience what he's doing, accusing me of something I didn't do. Right? So what's going to happen, Jamie? Are you going to try to file an expedited hearing? Are you going to email the judicial assistant tonight or tomorrow and try to get an expedited hearing, which would probably be 7 days before the motion to dismiss anti-SLAPP? Is that your master plan, Jamie? Because here's the thing. I'm 10, 100, 1,000 steps ahead of you. Because here's the thing, James. And your entire audience over there can listen. We'll handle the restreams another time. Give me a second. There's a big truck here. Yeah, it's okay, Lewis. Here's the thing. If you file a motion for an expedited hearing, I'm going to object to that. I'm going to let the JA know that this is very close to a dispositive hearing, and it would prejudice me from being able to properly prepare for it. If that hearing is somewhat granted, at that point, I'm going to file a motion for continuance because of prejudice. I am putting this out there, Jamie, because I'm trying to think, what is your play here? You shouldn't really be doing that through the court. What is your play, right? Because regardless of what your play is, I'm going to respond and protect myself from your play, in my opinion. Right? So if you email the judicial assistant tonight or tomorrow and request an expedited hearing, which would be in 5 business days or so, that would put us right around April 1st, April 2nd. Then April 9th is what? 7, 8 days away? You're going to force me to prepare for another hearing, which I'm going to win anyways because I didn't violate the agreement. Thank you for the $1.99 super chat. Oh, well, thank you for that. Is that the play? Is that the play? Do you realize I did not violate the agreement? Do you realize me doing commentary with ODN is protected speech? We're not monetizing it. We're using small portions. And we're not defaming you. Are we insulting you? Absolutely. You insult us. You got nothing else, Jamie. You got nothing else besides trying to exploit me again through this parody. And you're trying to do it more legally. I will say you're going to try to do it more legally this time and weaponize the case, which is fine. You have the right to do parody as long as you're not being defamatory. ODN, are you screen recording? Give me a second. I'll be right back. We are back live. We are back live. Please put a 1 in the chat if you can hear me and see me. Put a 1 in the chat if you can hear me and see me. Thank you. Mrs. Holly, you're running your mouth again in Bill's chat, right? This is not about the April 1st. This is a different thing. Your buddy, the defendant, Mr. Jamie, has filed a motion to enforce a confidentiality agreement that I used a lot of his words in, exactly what he wanted. He's accusing me of breaching that, and I have not. And he basically is trying to gag me. He's trying to enforce the confidentiality agreement in a broader way than it was written And this is the way he wanted it written. Now, Holly, here's the thing. You want to keep finding things to stay pissed off at me for no fucking reason? Whatever. Right? It just shows how unreasonable you are. There's no reasoning with people that just hate people for the sake of hating people. Right? It doesn't matter, though, what you think. What matters is what's legally right and not. What matters is what's going to happen in court. Yeah, you can take a seat, like Tia says. Take a seat. Right? You see, here's the thing, Holly. You're not capable of doing what I'm doing. Most of you are not. And I'm not saying that to say I'm any better than any of you. But I truly stand up for what I believe in. And I don't play nonsense games at the age where we're all at. You guys are in your 30s, 40s, and 50s. You should all grow the fuck up.
What's up? Can we say hi?
I can't have anybody on, sorry.
What is it?
I'm recording a video.
Okay.
Yeah, see you later. Uh-huh. I cannot have people on that I don't know how old they are. I mean, they were nice, don't get me wrong, but I can't take any chances when there are things that are questionable, right? Anyway. Yeah. Well, a lot of them are just not in their right headspace. A lot of them are very dysregulated and they need this to regulate, right? And Bill, let me tell you, no one's going to feel sorry for you no matter what you're going through right now because you're still stealing my content, Bill. So yeah, Jamie last night tried to get people to feel sorry for you, right? And I'm like, I'm not buying that. I'm not buying that because the guy will be back. Yeah, you're probably right, babe. You're probably right. A lot of those people are thirsty, A lot of them are thirsty, man. It's okay. Whatever. Why aren't you talking in Bill's chat, Jamie? Are you embarrassed because you know you made a mistake? Are you embarrassed that you filed a motion to enforce the confidentiality agreement and sanctions, and now you're looking at it and you're like, oh my God, I made a mistake? And even if you try to retract it, it stays on the docket. Maybe he'll never file a hearing for it. But we'll see. We'll see. What are you going to do? You going to file an expedited hearing, James? You going to let it sit on the docket and never file a hearing for it? Just let it sit there? You're going to use it as evidence for the anti-SLAPP? Did you just want to get a reaction? Because it doesn't matter. I'm just going to share my thoughts anyway. Right? Here's the thing. You've never, ever won against anyone in court, Jamie, ever. And so far in this case, you've lost every hearing or every aspect that requires a judge to rule on. You've lost every aspect. This confidentiality, motion and sanctions, you're going to lose that too. 100% confident. Because I didn't violate the agreement. You haven't given me one covered video. That covered video is coming on April 1st at the latest. Now, when you give me that video, that's the only video that's protected on your end. On my end, I have the ones that I gave you at the spoliation hearing in February, right? So what are you trying to pull, man? Are you trying to make as much money as possible before the court forces you to stop at some point? Is this a play for the anti-slap? What is your play here? Because I know you've read the confidentiality agreement. You helped write it. I used language in it that you gave me in an email, which will be used against you at this hearing. And if you don't file for a hearing now, at that point, I have to wonder, why did you file the motion in the first place if you're not going to file a hearing to enforce the motion? I got a lot of people I'm running into tonight. I'm just going to wait. There are a lot of people at the park tonight. All right. People are just stopping. I'll just go this way. I have the right to do commentary on you, Jamie. I have the right to use clips of yours under fair use. I'm also not monetizing them. I'm not making any money off them, and it's not affecting your use on the marketplace because all those videos are not publicly available, and I got them before they were not made available, and you never produced them to me through discovery, which is the only aspect of our confidentiality agreement. If the people on your end that are very simple-minded actually open up their eyes and try to understand what I'm saying, then they would know what that means. You trying to gag me? Are you mad that I'm doing commentary right now? In the same ways that you claim you've done it to myself and others? The difference is you commercially exploit it, you monetize it, and you use entire streams and videos. We don't commercially exploit it. Heck, we don't even monetize it at all. And we use small portions. And our commentary is way better than yours because it's the damn truth. And you don't want the truth out there because the truth destroys your narrative, man. You are a pathetic individual. You could take that right to the judge. You are absolutely the worst litigant that's ever lived, in my opinion. And I have the right to make that opinion. You are the worst litigant. I mean, I'm trying to sit here and think, what is your strategy with this motion filing? Did you want a reaction from me? Do you want to use this for the anti-slap? Are you going to try to file an expedited hearing to try to slow me down for anti-slap prep? What is your plan here? Because I'm calling it out. Let's call it, again, preempting the narrative, which you didn't do that to me. You never preempt my narrative, but I preempt yours all the time because you're that predictable, man. You're that predictable, right? You're that predictable. You're that predictable, and you're extremely despicable. Despicable. What's your next move going to be? I look forward to the potential email tomorrow morning. You emailing the judicial assistant, carbon copy me, requesting an expedited hearing. Trying to say that this is urgent, and I need to have this resolved before the anti-slap. You're going to try to mimic what I did. I did it for legitimate purposes. Can you folks hear me? One in the chat. One in the chat if you can hear me and see me clearly. One in the chat, please. Can you please put a one in the chat? Thank you, babe. Well, the bottom line is he will not stop until I get a permanent court order regarding his conduct. Right? He will not stop the commercial exploitation, the defamation, and all that. Right? And the copyright infringement we're going to handle in federal court when I get the certificates. Should be any day now. So between now and the next month or so, I should have all 5 certificates. Why aren't you commenting in Bill's chat, James? Is it because you want to wait until your show tomorrow to talk about it? Don't worry, we'll be there screen recording because you're going to delete the evidence, right? Right? I'll tell you this, man. Everything you delete, if you, same offer to you again. If you want any deleted video, even a third-party one with ODN or any ones that I've removed, put to private, all you have to do is email me. I'll get it to you right away because that's how reasonable of a person I am. And the next time I need a video from you, I'm going to ask you. And if you force me to discovery again, then we're going to do the whole thing all over again. All right? Why play games, man? Is it because it's the only card you have? You can't win on the merits, Jamie. You never win on the merits, but you have to try to wear out your opponent by doing the unexpected and trying to get them to work harder. Here's the thing. I'm not working harder. I'm working smarter. And the more that you try to pull this stuff, right? The more you try to pull this, see, that's why I feel you're going to probably have an attorney represent you. And you're going to have them file a motion of appearance at the very last minute, the morning of the April 9th hearing, which, if that's the case, I can ask for a continuance because of that. And I could claim, I just found out that the defendant has counsel. A notice of appearance was filed this morning, Your Honor. I request a continuance so I can look at my options if I need an attorney at this point, and moving forward right now would prejudice my right to a potential attorney. Tell you what, man, I know your game. I'm ready for everything. I'm the one that you can't manipulate, Jamie, ever. I'm the one that your shit won't work on. Whatever you try, I'm already thinking way ahead. And I already know what my answer is. Right? And whatever, you people are sitting there, you and your cronies over at Bill's, right? Stealing my content still, right? The bottom line is you're still hearing everything I'm saying, right? And what your audience knows is that all your dumb shit you do on YouTube doesn't matter. What matters is what happens in court, right? What matters is what happens in court. So what are you going to do? You're going to file a motion to expedite this hearing and say that it is critical to the anti-SLAPP to enforce the confidentiality agreement that I didn't violate, because it is impossible to violate when you've never given me any video that qualifies. The only one will be the first one that you were court ordered the other day to produce to me by April 1st. I'm already ready for the hearing. I started preparing over 2 months in advance. So you're not slowing me down. But at the same time, at the same time, it would take a lot of my energy to focus on a separate hearing a week before a major dispositive hearing. Dispositive means it's a hearing that could end the case, right? Someone in here earlier was telling me that BVAS guy is rebroadcasting Dennis every day. Maybe I should pay BVAS a visit, right? Or maybe Odin and I should start to do some commentary on BVAS's streams, right? You people that steal other people's content, it's one thing about the copyright infringement. It's another thing that you're pathetic people that have zero substance and zero creativity, and you're selling yourselves short because you're showing that you really have nothing to give to this world by way of content out here on YouTube or any other platform that people produce content on, right? Gonna go live tomorrow, Jamie. You're gonna make the filing in the morning, right? You're gonna email first you gotta file it. Here's what you're gonna do. Now I missed the part. Before you can request for an expedited hearing, you have to file a motion. Motion for to expedite it. So that's what you're doing. You're working on that. You're gonna serve me with that. And then after that, you're going to email the JA, right? I forgot the one thing. You have to file the expedited motion. Now, that I could be wrong on that, because if you want an expedited hearing, you already have a motion. And it's not to shorten the time. Well, it is to shorten the time of the hearing, but not to shorten the time of producing evidence. So you may not even need to file a motion for that. You just need to request a hearing. Okay. So yeah, forget about that. You might not need to file a motion for an expedited hearing, because my motion was for an expedited discovery request that typically gives 30 days. You have a motion to enforce the confidentiality agreement, so you don't need to file another motion. You just need to request an expedited hearing and give a reason that's compelling enough. A little over 2 weeks away from a major dispositive hearing. I mean, you're going to lose this hearing. You know it. You know I didn't violate the agreement. Everybody on your end is hearing it, right? Everyone on your end is watching the replay that Bill is watching the restream on Bill's channel, unauthorized restream, by the way. And they're hearing me speak of the truth. Here's the thing. To all of you over there at Bill's side, okay? If you want to go and see the confidentiality agreement or any other publicly available document on our case, go to search Seminole County, Florida, case search. You go there, you click on civil or circuit civil, enter my last name, Melas, M as in Mary, E-L-A-S, M-E-L-A-S. You will see, when you search by my name, you will see my name there and the other guy's name. Go in there and scroll down until you see the confidentiality agreement, and go read it for yourself. Go read it for yourself. Why do you people over there on Jamie's end, do you believe everything that comes out of his mouth? Listen, I don't care if you hate me. I get that. I'm cool with you hating me. But have some common sense. Go and read this agreement. And then when it hits the docket tomorrow, I don't think it hit the docket today. It might have. But it either hit it later today or it'll hit it tomorrow. Go and see what he filed, which should show up on the docket by tomorrow to enforce the confidentiality agreement. Go and read that. And then you'll see, right? Like, do you people support people that just attack and criticize people you hate, whether they're right or wrong about other things? Seriously, I just don't understand where your values are based at or based off. What do you think about the confidentiality agreement, Bill? What do you think? Tell us your thoughts. I want you to tell me specifically, Bill, if you support Jamie on his motion to enforce the confidentiality agreement. I want you to do a show and break down the agreement and tell me specifically what I violated and show me proof. Because there's no proof. The defendant, you never file any proof. You have no proof. I mean, do you think that I'm not going to see what you wrote and understand that you're trying to broaden the agreement? Do you not think Judge Stacy's not going to see that? I mean, I just don't get the tenacity of these people, right? And Bill, if you think I have violated you in any way, take some legal action on me and I will countersue you. I'm not violated you in any way. And your name is part of the public record, Bill. I'm not going to say it on my channel here because you people just flag over everything. You people are so pathetic and miserable, right? And a sorry excuse for, I won't even say it, that you folks want to harm people that first you're doing commentary on and saying lies about them, and when we respond to share the truth and to correct the record, if we say like your name or something, you guys look for any reason to take us down, right? You look for any reason to silence us, right? Just like Jamie, you want to admit you want to silence me, Jamie. Admit you want to gag me. I'm not trying to gag you. I don't care if you talk about me. I care about defamation and copyright infringement. You can talk about me all you want. I'm walking at the park. This is just myself and my camera. This is 100% original content. You're not original, right? But you are trying to gag me for, I don't get it. Do you not like the fact that Odian and I are doing similar things that you've been doing for a while? The difference is we're not monetizing it and we're doing fair use properly. And then you tried to share, you went off on your community wall today, James. You're so triggered over getting a court order on you. You were so triggered. You went off on your wall. You're sharing that parody thing. You're trying to get to $1,000 by Thursday because the timing is of essence for this hearing coming up, right? Right. You want to hit me in every way possible, right? Do you think you're going to affect me? No, you're not affecting me one bit. I'm actually laughing in your face, James. And everything that you say you're going to use against me in court, I'm going to use against you in court at the anti-slap. You're trying to silence me while trying to get an anti-slap on me, right? You're trying to silence me through this protective order that I didn't violate, but you accused me of it, and you want to get sanctions on me for the second time. You're trying to get sanctions on me now. And don't think that won't be noted for Judge Stacy. You tried to get sanctions on me at the spoliation hearing. Now you're doing it again. 2 weeks before the dispositive hearing. Do you see the pattern, man? And you know I'm so good with my filings and I'm great in court, unlike you, right? Here's the thing. You might be making more money than I am right now. You're stealing. You are absolutely stealing because the law hasn't caught up with you yet, but it will. Trust me. The walls are going to be closing in there, James, right? Trust me, the walls are closing in. That's why you're getting triggered, because the walls are closing in, right? You never thought I would get that video. And I'm telling you this right now. There's no way in hell that you're going to get sanctions on me for something I didn't do. And if you actually file a motion hearing for this, and you actually force us to go to a hearing over this again, especially if somehow it's granted in an expedited way, at that point I would have to request a continuance for the April 9th hearing, because I'm not gonna let you prejudice me by trying to load up another hearing, trying to do whatever you can to get an advantage in the anti-SLAPP by trying to wear me down. Judges won't let that happen, James. Judges won't let that happen. I won't allow that to happen. I've got options and I've got my rights. And guess what, James? Every time I've filed something, it's been handled. Look, I requested a protective order. Instead, Judge Stacy authorized the confidentiality agreement. Same thing, but just between you and I. I still got what I wanted, what was right. And now, you're the one that narrowly tailored that thing all the way down to covered videos are only videos produced or exchanged through or in discovery, right? Through discovery, right? And now you're trying to broaden it more? Are you okay? Is this all you have? Acting like a goofball in front of other goofballs that are watching me on a restream, right? That have a reckless disregard for the truth and the law, right? A reckless disregard, right? You enjoy being a goofball and doing dumb things because you think it makes you look like a superstar in front of your pathetic, miserable audience that's no better than you. You're all the same. Babe, start getting your quote in. Well, it's going to have to wait till the copyright court, because I'm not suing for loss of income in the civil case. In the copyright case, I'm going to be suing for statutory damages, up to $150,000 for willful infringement times 5 certificates. So I could be awarded anywhere from $750 to $150,000 per piece of infringement that I'm filing, and I'm filing 5. So the copyright case is going to be very, very serious. And Jamie knows how good of an attorney I'm not an attorney, but how good of a pro se, acting as my own attorney, pro se, self-represented litigant I am. I'll be even better in copyright court, James, I'll tell you that. But the one thing that I am going to file for after the motion to dismiss anti-SLAPP is done with and we move forward is I'm going to request punitive damages. And I have shown such malice intent and reckless disregard of the truth and reckless disregard in general that I think I have a good chance of Judge Stacy, granting punitive damages. Rock, are you serious with that, or are you just playing, man? Because either way, it wouldn't really matter. I'm just wondering, are you just having fun, or is that an actual truthful statement that you're saying, or is that how you honestly feel? Respectfully, maturely, and professionally, Don's quote: "Defeat can bruise the ego. When goals slip away, some turn that pain outward, projecting I can't even read that chaos, so avoiding facing the quiet work of starting again. Defeat can bruise the ego. When goals slip away, some turn that pain outward, projecting chaos to avoid facing the quiet work of starting again." Amen. Okay. Well, I mean, I just got to say this. The motion he filed today, wow, I don't even know what to say, right? Like, if I filed the motion like that recklessly, I mean, I would practically be throwing my case away. I would never do that, right? And he's got to know that was a reckless filing. But there's another method to Jamie's madness. Like, when Jamie does something that you would least expect, right, like this, there's always a reason for it. And I'm going to know sooner or later what that's going to be, right? His next court move, if he files this expedited hearing, I mean, he may try to bring this up at the anti-slap. And at that point, it's going to be, Your Honor, the scope of this hearing is limited to the motion to dismiss and anti-slap. Unless this directly ties into that, it's out of the scope, and we shouldn't be spending time on something else. This is a serious dispositive hearing. Something like that, right? So, I mean, I'm trying to think of every single card, every single thing this guy is going to try to play, right? He can't adjudicate copyright in the circuit civil case. He can't say, "Oh, Eli's stealing my content," while accusing me of that. No, I'm just saying commercial exploitation. You are commercially exploiting me. But we don't do it to you. You can't say that ODN and I are commercially exploiting you because his channel is not monetized and we are not accepting donations. All we're doing is responding to things where we want to clear the air and spare our reputation from what you're saying about us. That's it. Nothing less, nothing more. We're not making any money off it. We don't want to make money off of it. We don't care about the money in that aspect. We'll make money other ways, legitimately. But what's your play, man? What's your play? What is your play? Because honestly, here's the thing, Jamie. Why don't you, if you do a live stream or a community posting, how about you explain specifically within the confidentiality agreement, what did I violate specifically? Because in your filing, you didn't attach the confidentiality agreement. You didn't refer to it. You said a few things in there, and everything you mentioned is listed as an exclusion from the confidentiality agreement. So why don't you do a live stream or a community posting and show us specifically what part of the order did I violate. If you do a live stream tomorrow, Jamie, and you avoid going through that agreement and showing what you are accusing me of violating, I'd like for you to show people. If you're such a big man on campus, you filed a motion, you filed sanctions. Show us why you filed that. Where did I violate the agreement? Your audience should be asking you, okay, you're saying that you're going to get sanctions on Eli, so show us what is sanctionable. To you people out there, to you Holly, Bill, Tammy, all of you, ask him to show you what is sanctionable. Or do you folks not care because it's just content? Are you also weaponizing the court system for content? You see, here's the thing. In my opinion, James, this is just my opinion. I'm not accusing you of anything. In my opinion, if you can't go live or show exactly how I violated this confidentiality agreement, show us the actual agreement. I don't care. I'm a public, I have a public name, right? My name's out there. I don't care. Show it. If you can't show what I violated specifically, then the only other logical thing is you're weaponizing this court case for content. Show me what you're going to argue in court, because what I'm going to bring in court is the agreement and show line by line that it is impossible, Your Honor, for me to have violated this because, first of all, at the time that the defendant filed it, he hadn't produced one video to me that's covered. Now, by the time, if we have a hearing on this, I will have already hopefully received the video you've been court ordered to give to me by the first. And if you don't give it to me by the first, then I'm going to file a motion to compel production of evidence, and then you're going to be violating the court order. Right? You accused me of something when, none of your videos qualify for the agreement yet, because you haven't given me anything through discovery yet. You're about to give me one thing through discovery. You know, that agreement was something, and here's the funny thing, Jamie. That agreement was something you were hesitant to agree to. But now you want to turn it around and weaponize it on me and say that I'm violating the agreement. Wow, man, you are really, here's the thing, man, you are really, I don't even want to say it. I'm not going to say it here. I'll hold off on saying that stuff for ODN's channel. Right? You know why, James? Because that way you can't platform enforce me here. Because you want to try to get me platform enforced, right? You will not show how I violated the agreement. You won't, because you know I didn't. You won't. Your audience should question you on that, right? And if you're saying I'm not allowed to talk about it, that's part of the agreement. The agreement does not gag speech. I'm telling you this, man. I look forward to the anti-slap. I look forward to the anti-slap because you're trying to gag me while trying to slap me with an anti-slap. You are despicable, man. You are despicable, and you're just, in my opinion, not a good human being. You're not a good human being. You are a liar. You are inconsiderate. You are extremely, extremely, extremely insecure and weak. You should start toughening up, man. Start toughening up a little bit. Start doing the right thing. Stop feeling the need to hurt other people just to feel better about your miserable, pathetic self, right? I'm no doubt you're going to lose that hearing. And you could file that with the judge, because all the judge is going to care what is procedurally right. I didn't violate the agreement. You know I didn't. If you actually file, or if you actually request a hearing for that, especially expedited, right, you're going to see what my next move is going to be. I'm not afraid. I'll give you all my moves. It doesn't matter. I can give you all my moves. It doesn't matter, because what matters are your moves. My moves, I don't care. I want everyone to know my moves, because I'm not afraid of anything, because I've done nothing wrong. I'm protecting myself and defending myself and trying to get you to stop violating me. You're trying to find some kind of loophole to squirm your way out of this, like you've done every other thing in your life. You squirm your way out of every aspect of life, and then you've gotten in trouble regarding people that bailed you out. James, you're not getting bailed out this time. You're not going to squirm your way out. No way. Make your parody, whatever. Bill's going to restream, whatever. You're going to do what you're going to do. But come 17 days from now, when this case continues, and at that point, you got to decide, do you hire an attorney or not? And hey, at that point, you're going to have a second case to deal with, the federal copyright case. You know what, James? Things are going to start getting even more fun. Things are going to start getting even more fun. That's my protected speech. The more and more you try to challenge my speech, my lawful speech, when you slapped me with an anti-slap, we're going to use that all against you on April 9th for the MTD anti-slap portion, the anti-slap portion. Time to go. Have a good one. Take care, and as always,